So we have with us Dr. Aniruddha Malpani, uh, Advocate Neha Gyamlani, Advocate Aditya Jain, and I think Advocate Puneet. So I'd just like to everyone to introduce themselves first. So we can start with Dr. Malpani.
Yeah, hi, I'm an IVF specialist and an angel investor.
Okay, and Neha.
Hello all, I am an independent practitioner at Rajasthan High Court. Uh, my firm is Jain Advocates. We are working in healthcare sector.
And Aditya.
I am an advocate on record in the Supreme Court, and I am a founding partner of a law firm, G&G Advocates, specializing in healthcare laws.
And Puneet, I think you're unmuted now.
Yes. My practice primarily encompasses cyber laws. So for the past 12 to 13 years, I've been in the space of cyber law, which is digital security. And the telecommunication laws also included in the same. And yes, healthcare now going into the digital space also comes within the same ambit.
Okay, great. So I hope to have a great discussion. So we can kick off the things with like one of the what I feel is important is like it took 20 years for the regulations to come in. I mean, the Telemedicine Association has been lobbying since 2001 too, and it finally took a pandemic for it to get past the regulation. So I'm getting some request for a unmute, but I'm not able to do it. Ramanuj, Neha, can anyone hear me out? Galaxy J7. Dr. Malpani, any views on this one? Like how we had to wait for a pandemic to push through the laws, and then we can take the view of the lawyers on this.
Every crisis is an opportunity. And, I think it's great that the laws, basically laws and frameworks are protective, but people were doing it in any case. So, people have been using telephones for doing consultations for donkey's years with or without laws or frameworks. So I guess, medical professionals have enough intelligence to be able to understand what to do and what not to do. And they understand that they can help their patients, not necessarily only by face-to-face, but there are other tools to be able to do it. And honestly, I just think, teleconsultation done on a Zoom call or on a WhatsApp is just an extension really of a telephone call. People want that protection because in case something goes wrong, you don't want someone complaining that you didn't follow the rules. So I guess in that sense, it's helpful that people know exactly what guidebook to follow. But I think, like I said before, people have always been doing teleconsultations. Typically, they were doing it for existing patients whom they had a relationship with. So it could save them the inconvenience of actually commuting, coming to the clinic. So that was a great value add. And I think it will just become more mainstream now.
Mm-hmm. And anyone from the legal side wants to take on this?
I would like to say that, can everyone hear me?
Yeah.
So I think with the new telemedicine guidelines, practice guidelines of 2020, which were introduced by the Ministry of Health and Family Welfare, in consultation with Niti Aayog and Medical Council of India, we now have telemedicine practice guidelines. However, what concerns me is the fact that we do not have a codified law as yet for practice of telemedicine professionals. Telemedicine regulation is important because as we see now with the advent, we don't have an adequate public health system. We are facing acute shortage in that. Apart from that, telemedicine, talking globally in Malaysia, in US and Canada has achieved enormous proportions and it's actually functioning well. Especially I would say Malaysia, because the Malaysian Act of 1997, as early as 1997, they introduced telemedicine, which is very commendable. India, as we say, we now have telemedicine practice guidelines, which are good, which is a good step. The guidelines are actually a blueprint for the future. They are not really exhaustive, but they mention certain important, they address actually certain key measures. I would not go into the security related aspects because I think Puneet would be in a better position to answer that, being a cyber lawyer. I would only talk about the regulatory aspects and the responsibilities which have been fastened on telemedicine professionals now by way of these guidelines. One is these guidelines have introduced various relationships which are very important, I would say. One is a relationship between a patient and a registered medical practitioner. Second is a relationship between a caregiver and an RMP, registered medical practitioner. Third is telemedicine between RMP and RMP. And fourth is health worker to RMP, basically consultation. Now, what I would say is that there were laws in force. There was the Medical Council of India Act, 1956, Section 33, which gave the medical council to make regulations for conduct of medical professionals. But these guidelines have actually laid down a structure. Structure is important because there was no structure as well. Now, these guidelines interestingly also talk about various lists which are there of certain medicines which could be prescribed, which could be certain medicines which could not be prescribed. So they are in a way very diverse, I would say. Apart from that, one other peculiar aspect of these guidelines are that they have basically laid down various regulations with regard to prescriptions and post follow-up and first consultation. Now, what is most important in telemedicine is to lay down separate guidelines for first consultation and and follow-up care. Now, there are certain medicines which can only be prescribed during the first consultation, and there are certain medicines which can be only be prescribed during the follow-up care. And there's certain medicines in prohibited list which cannot be prescribed at all during the telemedicine consultations. So these guidelines are very important. I think the doctors, the medical professionals need to go through these very properly and need to understand as to what their responsibilities are, because it actually puts a very strong onus on them with regard to maintaining their records, with regard to making sure that they have this adequately store the data of the patients, and so on and so forth. Also, one important aspect of it is it requires the doctor 3.7.2 of the guidelines rule. It says that the doctor should maintain the log on and the log out record of the patient as well. So that is I think a very important aspect of it.
Okay, thank you, Aditya. So now coming over like from the point of law to coming to a more general thing, like how do you feel telemedicine is going to actually help our healthcare system?
Yeah, should I go proceed?
Like anybody wants to take this?
I think Neha
Yes.
would be.
Neha,
Yes.
Neha is speaking. So
Yes, hello. I would like to just tell you in brief that what is telemedicine firstly. Telemedicine is delivery of clinical services to the patients, which generally happens through the physical doctor-patient relationship. Now, what these telemedical medicine will do is now that it will go on through the information and the communication technologies and deliver services to the patient. On the other hand, telemedicine is a component of telehealth. Telehealth, which is a larger concept or a broader concept, it it inculcates the education, the administrative meetings of the registered medical practitioners and the hospitals between them. Now, it is very true that this pandemic has brought the telemedicine and the concept of telehealth, e-health, mobile health into the forefront of the discussions. And also, it is very true that the businesses, if they have to survive and sustain, they have to soon, there will be a requirement that they shift into the telemedicine because of the contagious disease it is. So I would like to tell you basically that what was the law on the telemedicine before this. The law on telemedicine was with respect to MCI Act, it was with respect to drugs and cosmetics, NDPS Act, clinical establishments, that all the clinical establishments have to follow certain guidelines. All the kind of telemedicine was happening before also. For example, they were following the IT Act and the IT rules. Now, in the with respect to the Epidemic Diseases Act and the IT rules, there has been the guidelines which came out on 25th of March 2020. They specifically talk about how do a medical practitioner has to do the telemedicine, has to practice telemedicine. So these are the basically the general provisions. Now, I would like to also talk about the digitization of health. Now, the digitization of health is not a new concept. The government is committed to a digitization of health for the all the population, for providing them access to healthcare. Access to healthcare also involves the affordable healthcare. Now, the rural people living in the rural areas, India has demographic and geographic disparities. People who are living in the rural areas, they have to come to the cities for the hospitals and for a quality medical care. In their areas, we don't find any quality medical care. So telemedicine for them would be a boon. Secondly, the demographics. For example, as digitization has shifted towards the more younger population and now even the mid-age populations and up till 50s, so they are also using telemedicine very popularly. For example, in the diet care, they go for telemedicines. For pediatrics, it is very well used. For remote monitoring of your diseases, it can be very well used. In the COVID-19 times, there's been concept of the pulse oximeters, which can at home, from home, you can tell the doctor about your oxygen levels, so that if there any treatment which can be done prior to when you are infected, so that can be detected. So all these concepts were before also. Only thing is that this COVID-19 has brought all the telemedicine and the mobile medicine into the forefront of the discussions.
Okay, so that is a very nice legal point of view. Now, I would like to ask Dr. Malpani, sir, how do you see this new guidelines or the current situation of the COVID pandemic pushing people or pushing the health system towards telemedicine? How is it going to actually help our health system? Like, how is it going to healthcare in general? How is it going to
See,
help?
don't forget, doctors have been around for centuries. Patients have always fallen sick. And you want healthcare ideally to follow the 4 A's, which is it should be available, accessible, affordable, and accountable. Some of the advantages are obvious. Like I keep on saying, it's just an extension of a telephone. You've just added the video, you've added a lot of layers. And I think sometimes these things are good and sometimes they're not so good, because then people worry more about filling up forms and making sure all the paperwork is correct. And sometimes it becomes a confrontational thing where I think the tragedy is sometimes the trust between the doctor and the patient has been lost, because people kind of say, oh, I have to do this, I have to do that. And doctors are much more careful. Think about it. If a doctor is worried, oh, this is being recorded, and in case I say something and then it backfires and then the patient sues me because I didn't do a clinical examination. So ultimately, doctors are going to start protecting their backsides. And they're going to say, this is my advice, but I think, it's much safer and better for you to actually physically come in. Or they'll say, yeah, go to the nearest emergency room. So I'm just trying to say that everything which has good intentions can also be gamed. We need to be aware of this. But good doctors don't require regulations. And bad doctors, no matter how much you regulate them, are going to find a way of screwing the system up. And, a few bad apples is going to ruin the entire bushel for me. And this is going to create a lot of work. And at some point, patients are going to get upset and they're going to go to their friendly lawyer and say, "Arey yaar, मैंने teleconsultation किया था Monday को, Tuesday को मेरे father को heart attack हो गया." इसका सीधा मतलब है कि वो teleconsultation डॉक्टर ने ठीक नहीं किया, डॉक्टर मिस द डायग्नोसिस, तो अपन डॉक्टर को सू करेंगे. Whereas obviously we can't prevent a lot of this stuff. So I think a lot of it is now going to be checkbox medicine or cookbook medicine, just like it's happening in the US. So that element of trust which doctors and patients had, because, hey, I look after you, I care for you, I want to make sure that you're going to get better, is gradually being evaporated, because we're going to care more about making sure that we follow the regulatory norms than anything else. And no doctor is going to want to take risks. These are some of my concerns. We need to think about some of these unintended consequences. But if done well, like it's always been done for so many years, with or without regulations, it makes care more available, because wherever you are, the doctor is accessible, including the GP, including the specialist. Doctors can get second opinions. And like she quite correctly said, once medicine gets digitized, it becomes much more seamless. You can get an e-prescription, get the logistics guide to deliver it to your house, so you don't need to waste time with the commuting, and it obviously helps to reduce costs. But we should worry about how people will game the system. Life is never as straightforward as it's made out to be. That's it. Hi, can you guys hear me? I always worry. I'm
Yes.
done.
Okay. No. So actually, I was muted by mistake. So I was trying to get myself unmuted.
Sure.
So yeah, thank you for that. And another thing that you keep on, I mean, in fact, you said it for the program of this, the agenda of this today's webinar, that information therapy.
Yes.
So can you throw some light on that, that you keep on talking about information therapy, and you also said that telemedicine guidelines and proper framework could actually help information therapy, that doctors teach their patients well to take care of themselves.
Yes. So, okay, let's not look at the bad actors for some time, but obviously lawyers only get involved when bad actors come in, which means there'll be 1% of doctors who will create messes for whatever reason. And that's the only thing which will ultimately go to court. And 99% of the time when these telemedicine consultations go smoothly, no one will ever hear about them. But that's a different thing. So I don't want to go there. I think the good thing is doctors are going to force to be much more transparent and open because they understand that things are being documented. They will spend a lot of time and effort in making sure that patients have realistic expectations. You know, it's like your bank makes you sign all those fine print documents, that you understand that this teleconsultation has its limitations, that the quality of care will depend on what information you provide. But in a good setting, doctors will provide templates for patients so they have realistic expectations. They can fill up as much accurate information depending on their particular context so that this then gets shared with the patient. So this creates some kind of a digital trail. And I think what will happen is good doctors will encourage this because they're good doctors. They want to make sure that the patients are being looked after, and they understand that the most important player in the entire healthcare system is the patient. We need to put our patients first. So we will proactively provide a lot of education and information for patients, which they can then access before they come for the teleconsultation, because a teleconsultation, a real life consultation is what? 5 minutes, 10 minutes, 15 minutes. But a patient has the rest of their life to lead, and they have questions, they have confusion, so that doctors will then start sharing all this digitally on their website so patients can access this information. So I don't think we need to look at only the teleconsultation out of context. It's part of a much larger ecosystem where patients will first access that, say, yeah, okay, fine, I know what I want to know, so I don't need to talk to the doctor. Or, hey, I found the information, but I want to know whether this information applies to my specific case. So they will ask very specific, tailored questions to the doctor, which is good for the doctor and good for the patient. Does that make sense?
Yeah, and also I'd like to add on, like information therapy, like what you are meaning is something that doctors will also communicate better with their follow-up cases if they're more accessible through telehealth, right?
Absolutely. I think it's in everyone's best interest. When, for example, there's a communication gap, the doctor says something, the patient doesn't understand it because patients are stressed out, tense, doctors in a hurry, doctors use medical jargon, 50 different things. At least when you put things on a teleconsultation, there's some kind of a record, documentation, a transcript. Patients can go back, look at it. Relatives can go back and ask more intelligent questions. The doctor's assistant can necessarily fill in the details. And typically what will happen is there'll be lots of FAQs, which doctors will then answer proactively using videos or on their website. So it will help to reduce some of the burden on doctors so they can then concentrate on the specific questions the patient is asking rather than the more generic ones.
Okay, great. And we have a question coming in from a participant that says it's for Dr. Malpani, but I think it is more suited for, I think we can ask Puneet to take it. It says limitations of telemedicine due to lack of internet infrastructure. So this is a question that, okay, we face problems as doctors who are in telemedicine. We face problems when there is a loss of internet connection. Let us say we are having a video, the voice drops, the video freezes, or even during a telephone call, there is a loss of network. So how does it affect a doctor and a patient doing a teleconsultation if there is a problem with the infrastructure, with the technical infrastructure, let us say?
See, from a legal standpoint, if I have to absolutely look at it, as per the current telecommunication guidelines of teleconsultation, and apart from that, the Information Technology Act, if we look at the overall gamut of the medical laws also in India, the liability on the doctor over here is quite less. So let's say if the internet service provider has an issue and the message has not been adequately conveyed, then in such a scenario, the liability which is there on a doctor is not to that extent that the entire message didn't get conveyed. Now, with teleconsultation, there are certain things doctors need to absolutely keep in mind, which are legal principles. So I'll even come to the point of who has the liability for the data protection, data security. Along with that, which are these different applications which are today offering services to doctors that you can communicate with your patients? And how does the liability lie there? But with respect to like putting all this in context, the first point that comes in is the concept of consent. So the basis of a doctor-patient relationship is consent. So when you go to a hospital, you are consenting and you're physically showing that level of consent by entering a hospital and seeking a doctor's services. Now, when you're talking about teleconsultation, the moment you approach a doctor, let's say over WhatsApp or over video call, you take an appointment, it's an implied consent that you want to be treated by this doctor. Now, does this implied consent apply to the treatment also? No, it does not. So, which means a doctor needs to take consent with respect to every single stage of the treatment, which is what we call an informed consent. So in medical laws, it's mandatory you have informed consent. So the moment you are given any form of treatment, you're informed fully of your diagnosis. You're informed of the medication, the side effects of the medication, everything is informed to you, and you make a decision to go ahead with the treatment. Now in India, traditionally, we don't see this happening. You enter a hospital, there is a standard consent even before you met the doctor that you're signing off on that I consent to everything. Now, in a physical scenario, a patient could never challenge something like this. In a digital scenario, when we're talking of informed consent, implied consent, a doctor will ideally have to get a consent signed off from a patient. Now, that can be done even in a digital fashion. It can be done over WhatsApp. It can be done over different mechanisms. That is to safeguard that, he has taken proper consent from a patient with respect to the treatment patient. The second thing is the diagnosis has to be very clearly mentioned along with the doctor's registration number, his capability. The second part of it, what exactly is the medication, which should be very clearly and legibly written. Now, why I say legibly written? Because normally if you see prescriptions, only the chemist mostly understands them. So for a patient, the chances of taking a wrong medication is very, very strong because he's just going to type out something and send it to a local chemist home delivery kar do. And if the medication turns out to be a wrong medication, the liability will fall upon the doctor. So ideally over here, when we are talking of informed consent and we are talking of absolute clarity between a doctor and a patient, ideally with a prescription, because a chemist will not give you medicines without the letterhead prescription, you need to, even over WhatsApp, very clearly mention the names of the medications typed out. So there is no confusion. At the end of it, you need to take an explicit consent of the patient that he has agreed to your treatment and is going ahead with the same and is informed of everything about the treatment. Now, in this entire thing, like even the reports should be shared. So any prior reports which are there, etc., should be very clearly a part of the communication. So it should not happen like, let's say if there are follow-ups going on, a doctor should ideally document everything, a short history, along with a documentation of everything that has occurred, including the past reports. Now here, the liability of maintaining those records lies on the doctor. So for every patient he's conducting a teleconsultation, he will have to maintain a patient record. So which will mean maybe ultrasound reports, it will mean prior prescriptions, and all of it which will be maintained on a digital platform. Now here, if he is using, let's say, cloud or any other service, let's say he's using Google Cloud itself where he's saving it. So the liability with respect to security of saving it in his device lies on a doctor, without doubt. So he needs to have adequate spyware, adequate malware, which is implemented over there so that his patient's data is secure. But let's say if the intermediary communication, WhatsApp, or let's say there are so many mobile apps providing a platform for doctors to consult patients. So let's say if that platform is breached, the liability does not lie on the doctor. It purely lies upon the platform whose cybersecurity has been inadequate. They have not been able to protect the data. And for that, the patient can only sue the platform and not the doctor. But let's say if the communication has happened over instant messaging like WhatsApp, and the doctor has a liability there to save the data, protect the data, then the question of a doctor's safety and security of the data comes up. So he needs to ideally end up having a very good, you could say, methodology of maintaining the databases of patients. So this is something which is prima facie very important. So even when you sign up for any platform, like a lot of doctors do have this query that, there are multiple platforms coming today, you sign up with us and you can consult patients. Now, a doctor should first of all read through what are the terms and conditions of such a platform. What is the level of security with respect to data that the platform is performing? See, what happens in litigation in these cases is now a patient, let's say something goes wrong. The patient is going to sue the platform, but for no reason he's going to add the doctor also as a party to the case. Now the case will not succeed against the doctor. from a legal standpoint. However, the doctor's reputation is going to go at stake. So choosing the right platform is also very important, which has adequate measures for data security. Ideally, there should be pseudonymization of data, which should happen on these platforms. There should be encryption of data. Now, what do I mean by pseudonymization? So here, let's say you cannot really protect the entire patient data, but yes, patient identity can be coded. So the entire patient identity is kept in a coded fashion. So even if, let's say, somebody has accessed the data, he will not know anything. He will just know A has cancer, B heart problem, doctor is so-and-so. That's irrelevant information. So there is nothing anybody can misuse this data for also. So pseudonymization of data, encryption of data, there are multiple standards and they are not so expensive. So the doctor needs to see the terms and conditions. They need to ask the questions as to how are you securing your data. So tomorrow my name should not come into the picture. So the liabilities of the platform, it should remain restricted to the platform. And even if I should not be dragged into litigation. The second thing is we should look into the nature of consent which is being taken by the platform. Because end of the day, the platform is also using the doctor. The platform is useless if there aren't good doctors on the platform. So the concept of consent has to be very clearly understood by the doctor. How is the platform good at that? How are they securing any form of records of the reports? So do they have a proper encrypted vault for the reports? The diagnosis. Now, if you know in India, a diagnosis of a patient cannot be shared with any third party. So a caregiver also, the immediate guardian or somebody can know the diagnosis and the information. Now here your platform, let's say there is a platform which is connecting a doctor and a patient. The platform knows the diagnosis. It's a third party which knows the diagnosis. So how are they securing that diagnosis is also something which has to be absolutely looked into. Ideally, with good standards of encryption, they need to ensure that everything is secure. A doctor's personal liability will only come for data protection where it is over WhatsApp, instant messaging, or any method where he is directly communicating without using a platform. Then he needs to ensure that he's securing the data with encryption, pseudonymization, anti-spyware, anti-malware. Definitely now all doctors should be having that on their phone because there are apps which simply screen your phone screens. Now, what do I mean by that? So let's say if a doctor is chatting with a patient and they're discussing certain diagnosis, there are certain apps which are very popular apps also, which people have on their phones, which actually take screenshots of every single image of the screen and then blackmail people. And it's very, very common. So if you realize how does your OTP of the bank go out, how do people lose money? You'll say, I never gave my OTP to anybody. But still money has gone out of your account because of the screen printing, which is what we call it, or screening of your phone. So a large number of apps every single minute are screening your phone. So the moment they see an OTP, the moment they spot some sensitive data, medical data, they know this is something that, hackers can use. And then this information is sold on the dark web for something like 500 rupees, and then you're extorted for something like 5 lakh rupees. So a good doctor needs to also keep in mind that his device should be secure. So anti-spywares, anti-malwares, good level of cybersecurity on a device, and ideally avoid using an Android device. So I would say BlackBerry or the Apple devices, obviously, because apps are vetted on the store, are much better. As much as possible, avoid Android. If you cannot avoid Android, then ensure you have a good cybersecurity background, which is there. And always vet the platform before you sign up for any service of providing medical service using any platform for a patient.
Okay, I have a follow-on question on this one, Puneet. Like, if this particular breach happens on the patient's phone, forget the doctor and the platform. Like, is this screening apps or like what you said, the ones that take screenshots? If such a breach happens on the patient's end and the doctor is blackmailed or the platform is blackmailed, for example, what is the legal standpoint on that?
See, over here also the entire onus is going to end up falling on the doctor to prove that his device was secure. So let's say if a patient's phone is breached and his medical condition is leaked out. So let's say he's some celebrity and his medical condition gets leaked out. Now, in such a scenario, what is this celebrity going to do? He's going to sue the doctor and the platform, right? So now the doctor and the platform need to have adequate cybersecurity in their devices and a phone and everything to be able to prove in court that, I have all of this secured in my device. Kindly do the forensics of my device. There is no trail of any data leaving my device. So the moment the device of the doctor goes in for forensics, it will be very clear that there has been no data. See, when we are doing cyber forensics, we can very easily from a device itself come to know what is the data that has gone out of the device and what has come inside the device. See, a
No, I
patient.
think we shouldn't operate from a position of fear and anxiety and concern. And I think HIPAA has been around for donkey's years in the US. We don't need to reinvent all this stuff. It's been done many times. And ultimately, we're trying to do this in order to help patients get better. We can't do it from a position of ye hoega to kya hoga. And doctor will say, jaane to main kahe ko karega. You know, here I'm charging less for doing a teleconsultation, and top of this, something happens, and unnecessarily I'm going to get sued. So every doctor is going to say, forget it. Why the hell should I lose money? You come to my clinic, or I'm not going to bother. I think we need to change our attitude. This needs to be an enabling platform which is designed to help people. My limited point is if you're comfortable transferring information about your credit card number online, where people can misuse that far more, I don't think we need to operate from a position of fear and anxiety. Doctors should have enough confidence in a lot of these platforms. And these are basic hygiene 101 measures, all of which everyone accepts. So doctors don't need to become technologists or need to worry about this stuff. You need to sign up on a regular platform, and there's enough encryption. Even if you use WhatsApp, for example, I think that's fine, which has all this protection built in. And if you're worried, then just use something which, which says they're HIPAA compliant, and I think you're good enough. I think the whole point is to provide an additional layer of comfort and security for the patient, that you don't need to waste half a day standing in a queue, commuting, going to a doctor. I'm available for you. Because if we come from a position of this is an additional way of strengthening the doctor-patient relationship and making care more available, affordable, and accessible, I think this will become a positive virtuous cycle. If, on the other hand, it starts happening that so-and-so got sued in a high court and the judge decided that the doctor was liable because he was careless or stupid or didn't know any better or whatever else, then the moral doctors are going to take from this is forget it. It's not of any value to me. Here I am trying to do a service, charging less, trying to make myself more affordable. And if one guy sues me, my entire lifetime reputation goes for a toss. So we need to provide that protection, but also that sense of security. That's been done multiple times in the other parts of the world, and we can do it too.
I would like to add to what Mr. Malpani said here. If you have a look at rule number 3.4 of the telemedicine practice guidelines, it basically segregates implied and explicit consent. Now, if a patient initiates the telemedicine consultation, it would be an implied consent. It could be done impliedly. Like if a person calls a doctor, that implies that he's given his consent. But there are certain categories of cases wherein explicit consent is also required as per the guidelines, which comes into force when either a health worker or a registered medical practitioner or a caregiver initiates a telemedicine consultation. So the onus is basically equally on both the doctor and the patient. Apart from that, rule 3.5.1 also talks about patient information. So it gives all the protections to the doctor as well. It basically says that the doctor is competent, has all the discretion to exercise on gathering the information, whether he want to take the telemedicine consultation forward or not. So he can exercise his judgment and thereon advise the patient. So 3.5.1 is really important. It says a RMP would use his or her discretion to gather the type of and extent of patient information required to be able. The information can be supplemented through confirmation, and if the RMP feels, if the doctor feels that the information is inadequate, then he can request additional information or he can deny teleconsultation. So it gives all the protections to the doctor. Apart from that, even if you have a look at section 3.7, 3.7 is also very, very important. It basically talks about basically maintaining digital trail and documents for teleconsultation. So the logon, as in the login and the logout details of the patient records, example, the images, the diagnostics, and the prescription. It basically, the onus is on the doctor then, but it gives the doctor sufficient protection as well. I would like to quote the example over here of the Agra e-Seva portal. If you have heard of it, the Agra launched its e-Seva portal in March 2020, just when the lockdown was announced. And it's been operating very smoothly, I guess. It's been operating smoothly because it is majorly following the processes as laid down in the guidelines. So what happens is, I'll just briefly make you understand the process of the Agra model, which has been adopted. A patient can request for an appointment online on the e-Seva portal. Secondly, the patient can then have a telecall. He can himself telecall if his if his appointment is approved by the doctor, then he can have a telecall or a video call with the doctor. Then the doctor would have to be stationed at the smart city command center. So there's a command center which has been formed. The doctor will have to give his advice from that center. That center will take care of all the data, and the patient can then download the prescription online. Also, if the patient wants the medicines to come online, then he would have to give his explicit consent. Now, one more thing, why all these telemedicine and everything guidelines came into force, that is very important. There was this judgment of Deepa Sanjeev Pavaskar of Bombay High Court 2018. In this particular case, one lady was admitted for pregnancy issues, and after that, she was discharged from the hospital. She again faced certain issues, so she contacted her doctor to ask for certain amount of medication. What the doctor did was she directly told her some amount of medicines to the pharmacist, and the pharmacist gave her the medicines. The patient took the medicines from the pharmacist. She was admitted in the hospital, and after some days she died. The doctor was sued for criminal negligence, and she was held to be guilty. Having said that, in this particular case, I would say this is a very landmark case in which Bombay High Court held that telemedicine, though, is very important, but it should only be used in cases where physical consultation is not possible, or in matters where of first consultation or follow-up care. So that is why the government came up with these guidelines, and it segregated list A, list B, list O. It segregated medicines which could be given under through telemedicine, certain drugs. So the guidelines are very, I would say, exhaustive, but they need to be codified in the form of a law to make sure that people do not face any issues. Also, the doctors, the high onus has been put on doctors to protect their data. I know, understand that, but the doctor is also free to exercise his consent. That is why informed consent is very important in telemedicine consultations. It needs to be informed, and it needs to be explicit, and that the patient has to give to the doctor. So I think these things are very important. We have taken cue of these guidelines majorly from Malaysian law, I would say, which is a very robust law. And the Niti Aayog and the Ministry of Health and Family Welfare came up with these guidelines majorly to make sure that such cases like Pavaskar's case and other cases do not arise in the future. The doctor is there, the patient is there. It could be used in cases where I would say telemedicine should be used majorly in cases which are general in nature, like which do not require the patient to physically visit the doctor. Of course, in cases of surgery, and telemedicine cannot be adopted, but in cases where I think it can be done through technology, I think telemedicine should be used. Yeah. Neha, would you like to add something? Yeah.
Yeah, I would. I definitely agree with this point, and also agree with Dr. Aniruddha with respect to the scare, which is not to be, or the onus, which is not to be shifted to the doctors. The guidelines very comprehensively have dealt with the cybersecurity issue, which is provided by the technology platforms. Now, these guidelines say itself that these guidelines are for the platforms which are enabling telemedicine. So, any mobile app, any website, any technology platform which is providing technology services to the consumers. Now, the consumers are two: registered medical practitioners, who are the doctors, and the second are we general people who are taking the telemedicine or the teleconsultation with the doctors. Now, these websites have to ensure that the customers which are consulting, these are consulting with the registered medical practitioners who are duly registered with the national medical records or the state medical registers. Secondly, these technology platforms have to do their own due diligence before listing any RMP, registered medical practitioner, on their online portal. So the ownership's on them if any doctor who is not a registered medical practitioner is teleconsulting to the customer. And the grievance redressal portals are also will be handled by these websites and mobile apps also. In event some non-compliance is noted, these technology platforms shall be required to report the same to the Board of Governors of the MCI, who then will see that whether the incompliance or any misconduct is on the part of the doctor or on the technology platform. So the onus is not on the doctor, and the doctors need not to worry with respect to the telemedicine practice, which they have to, which the government is enabling them to perform for the common people, for providing access to healthcare to all. Secondly, I would like to take on one more aspect of the medico-legal aspect, which is very important in this, is that the reimbursement and the payment policies. Now, what is happening is that in the general healthcare system, where the doctor-patient relationship is very physical and they go physical distance is not there. So the costs are very high. Now, in this, as Dr. Anirudh said, that actually the doctors will be giving services at a lesser cost. So why should they give the service at a lesser cost when the onus is already on the doctor, that they have to prove that the consultation we are giving is right. So all the judgment is given to the doctor in this by the telemedicine practices. They say just in one particular line that the essential guideline is their professional judgment. So to say in a layman's terms, even the MCI, even the government, everyone believes that it is the professional judgment of the doctor which would be the overriding principle over everything. Doctors cannot be single-handedly interpreted that they are held liable for their consultation. If they gave the consultation and the patient doesn't survive, or patient is facing any difficulty, so the doctor is liable. So this is very important, that the professional judgment of the doctor is the overriding principle. The professional judgment is built upon the 7 essential principles, which are again mentioned in the guideline itself, that how the doctor will build his professional judgment after taking due information from the patient, after patient gives his informed consent. So all these factors are definitely there, and it is already a comprehensive practice guidelines which the government has given. One more thing is very important, very latest on this is that the medical insurance. Now, what was happening was in various other jurisdictions, majorly in the US and the UK, that right now, if we claim medical insurance, the telemedicine wasn't there in the insurance. That anything happens, anything adverse happens to you, in case you are given the teleconsultation, there was no insurance. But just 2 days before, Insurance Regulatory Development of Authority has included the telemedicine in the list. They have given a list to the private insurers and even the government insurers that you have to include now telemedicine in your the basic claim policy. So this is very important development and a very significant development, which is for the patients. So I don't think anything, the patients are also compromising in taking teleconsultation from the doctors. One good thing is there that reimbursement policies were already there. Safe and secure gateways should be provided to the doctor so that their payment is not lost. Updated telemedicine infrastructure is the requirement and the need of the hour of our country, especially. And rest other things, I think they are getting updated as the this COVID-19 has posed many challenges and many things are on upfront and on upfront discussions. I think one by one, all the things are getting addressed. This is my viewpoint on the medical legal aspects of telemedicine.
Okay, so there has been another question coming in from the forum. Like this one is for Dr. Malpani, and it says like the, somebody wants to know, Anshuman wants to know what are the views on technology, that is IoT medical devices and artificial intelligence, which are a part and parcel of a lot of telemedicine platforms. So, Dr. Aniruddha, sir, what is your view on IoT devices or AI being incorporated into a telehealth practice? And to the 3 lawyers on the panel, what is the legal point of view on that? No, let's come from a
Yes.
clinical point of view first. Let's just get a response from Dr. Malpani first about the clinical aspect, and then we go to the legal aspect on this.
So, the trouble with a lot of these devices is they're created by technologists who fall in love with the technology and then say, okay, I have this clever solution. Now I need to find a problem to solve. And what they forget is that often the signal to noise ratio of a lot of these devices leaves a lot to be desired. And that's why wearables have never done as well as everyone thought they would be, that you'd get this constant stream of physiological data, which would allow the doctor to tell you what was going to happen. I think it's an exciting holy grail, but we're still a long way away from that. There are specific use cases, but don't forget, it always requires a certain degree of human intermediation, which means, for example, it's been well proven that patients with congestive heart failure who are at home should check their weight. You can easily put an IoT device. And if the weight increases in 24 hours by more than half a kilo, that means there's fluid retention. And that means that someone needs to go and see that particular patient, or they need to go into hospital. All I'm trying to say is that it's an entire ecosystem. As a technologist, you can't say, this is what I'm going to do. You also have to think of what the actionable clinical information is going to be based on that, which is then going to help the doctor to take better care of the patient. You need to start working backwards. You need to first start about improving clinical outcomes and then thinking about how the technology will fit in. You know, I'm an active angel investor, and one of the things often missing is what we call design thinking. And I think technologists need to spend a week in a doctor's clinic in a patient's shoes before coming up with all these clever gadgets and gizmos, which look really cool. So everyone does a pilot with them. And then after 3 years, you say, kya hua? Kuch nahi, because it didn't work.
So I would say that adding on to what Dr. Malpani says, I think AI, ML, and IoT are new things of the future. And basically, the guidelines specifically state 5.4 to be specified of the guidelines say that technology platforms based on AI, ML, and IoT are not allowed to counsel the patient or prescribe any medicines to a patient. Only a RMP is entitled to counsel or prescribe and has directly communicate with the patient in this regard. While new technologies such as AI, IoT could assist and support a RMP on patient evaluation, diagnosis, or management, the final prescription or counseling has to be directly delivered by the RMP. So basically, the guidelines clearly state that the AI and such technologies can only be used to assist the RMP to come on his professional judgment. They can only be used by him, but they cannot in per se give a consultation to a patient directly. So that is strictly prohibited. Also, 5.1 says 5.1 of the guide technology platforms enabling telemedicine guidelines. It says that telemedicine services to consumers technology platforms shall be obligated to ensure that consumers are consulting with RMPs duly registered with national medical councils. So it is the duty of the platform to make sure that the person consulting the consumer or the patient is duly registered with the medical council. So it puts sufficient onus on the technology platforms is there. Neha, would you like to add something to it?
Yeah, you are very right. All the kind of machine learning, IoT, artificial intelligence is prohibited in these guidelines. No, only a registered medical practitioner who is enlisted with the technology platform app is ensure is would be can give the prescriptions or the teleconsultation. No form of machine learning AI is allowed as of now, because anyways in India we don't have any law on artificial intelligence. One thing I would like to add here is with respect to one aspect we have missed actually, that is with respect to digitization of health. Now I would like to say here that digitization of health is not new. Digitization of health government is doing, looking at the population of 130 crores we have as of now. So what is happening is there is a national health stack. Now this national health stack is basically the uh, digital infrastructure of health infrastructure, digital health infrastructure of the whole nation. They are preparing all the kind of data for the patients. They've taken already, they have taken all the data from the hospitals, government or private, and they have the medical insurance details of the whole citizens of the nation. So everything is getting tracked as of now. And after this national health stack, once the data is prepared, this national digital health blueprint, which will be able to implement all these kind of data, like the HIPAA of US. It is very transparent and accountable. So all this data would also be definitely protected. As of now, these are only the guidelines from through which a registered medical practitioner would be able to practice teleconsultation. All the previous data of the government is won't be given to these registered medical practitioners or the mobile app. So we have to be very assured that whatever data the government is taking with respect to the personal health record framework for the nation, that is really very secure as of now, and no kind of artificial intelligence and machine learning is being used in these telemedicine guidelines as of now.
Okay, no, what I think my point of view at the beginning of this question was not about, because the guidelines are pretty clear on this, that AI
Yes.
and ML or any kind of technology should not be prescribing or counseling a patient. That right and that privilege or that part of the work like solely remains with the doctor or the RMP or the healthcare provider who is consulting.
Okay.
So my question and the question in the forum that had come up was more to do with IoT devices being used for telediagnosis, so that the doctor gets more vital information coming in from the patient and is easier for the doctor to reach a diagnosis and then go ahead with the prescription or whatever. So Dr. Malpani, actually that was the question I wanted to ask, like what is your take on not on IoTs and wearables and on continuous remote monitoring, but on basic connected devices that help a doctor capture the vitals from a remote location?
So, I mean, doctors use devices all the time. When you're checking a patient who's in front of you, use a blood pressure device. If the patient has a digital blood pressure at home and they're providing the information to you, so much easier. They don't need to come in. So it's very enabling. But like everyone's clearly emphasizing, the buck still stops with the doctor, which means the doctor has to be fairly confident the device is reliable, works properly. You can't, not all of them do, we know that. So a certain amount of trust and experience has to be built in. But all these are very valuable tools when they're used intelligently, and which is why the three ecosystems. The doctor has to be confident the stuff works well and his experience has to be good. Patients and their caregivers have to be intelligent to be able to use these properly. And the manufacturers have to make sure that these things are being provided. But the reality is that the technology is increasing so well that they all provide additional inputs. For example, when we take a diagnosis, we depend on the clinical history, we depend on a physical examination, but we also depend on what information the machines give us. Now what's happening is the machines are in the patient's home, but ultimately, as long as they're clinically reliable, which they need to be before they get actually marketed, I think doctors will be more than happy to use that information. Some people will burn their fingers because, you'll get some shortcut machines which aren't very clinically validated data, and that may cause a little bit of problem. So obviously manufacturers need to be careful.
Okay. And another thing that we have multiple people asking here is, do Ayush practitioners have does this new guidelines cover Ayush practitioners also? In my personal view, yes, because they are also a part of the registered medical practitioners in general practice and normal
Yes,
things.
it does.
Okay.
Definitely.
So another question.
Absolutely.
Yeah, thank
It's
you.
like asking, does it cover cardiologists and neurologists? I mean, these are all specialists. Everyone has a particular worldview. The patient is free to choose whom they want to go to.
Exactly. And one other aspect is, Puneet, this is for Puneet, like what is the, hello? Puneet, can you hear? Hello? Hello? Can you hear me?
I think there has been some issue with her video. She's just joining back. She can say hello or something.
Okay, but no, but the video is fine. Anyway,
Yeah.
so we have another one coming in here, like guidelines provide for training of all RMP who intend to practice telemedicine. Does it cover doctors who are already registered themselves on platform? So Aditya wants to take this one.
Yeah,
Okay.
it does. There's a 3-month course which has been prescribed. Though the details of the course have not yet been mentioned, they mandatory need to pursue that course. Whoever wants to, start telemedicine practice, whichever doctor or hospital, they need to make sure that they give their doctors or they themselves take this mandatory 3-month telemedicine course. The details of the course would be out by the government, but this 3-month course would be made mandatory.
Okay, I'll add to that point. Like from what I know is that the NMC has come up with a notification, not a guideline or not a course, a kind of notification that says everybody has to take this course within 3 years of the regular notification of this guideline. So from now, that is March 2020 to 3 years, so March 2023. And in between that period, the Board of Governors will come up with a specific online course that is designed to train RMPs to use telemedicine. Yes, to in answer to the question that came in, yes, we have to maybe wait a bit till they actually put forward the course, and most probably MCI or NMC or somebody is going to do that in short duration of time. And then, okay, Anshuman is again coming in with a similar question of lack of diagnostics in rural areas. So this one I would like to take as like the rural areas have a lack of diagnostics. All of us know that actually they have a lack of healthcare facilities in like in general. So what we were discussing some time back about the usefulness of IoT devices in telediagnostics. Actually, this is a very good thing for a rural or a remote healthcare setup in which there actually is no diagnostic lab, there is no doctors, there is not a, like the nearest healthcare facility might be 20, 30, 50 kilometers away. In that situation, a remote or a digital set of devices that actually takes the can help in forming a diagnosis. They don't cover everything, of course, till now, but yeah, that range of tests and diagnostics that we can do is actually growing. And a lot of these devices that are new ones, they are connected so that the data can actually be transferred directly to the doctor through any platform. And then that will help the doctor form a diagnosis and go ahead. This is more true of rural and remote areas, and the use case fits in there better than in case of, let us say, urban areas where you have facilities available in a walking distance or something. And coming on this point of now you're going around in IoT and AI for some time, I'd like to ask one to Puneet, like what is the liability of the all the stakeholders when there is a breach because of anything happening because of the, let us say, the devices or the AI ML platform? Because what happens, I'll just explain it a bit more. Like what happens is a lot of these systems work in collaboration with each other. Like what happens is maybe the device is manufactured by somebody else, the platform is being run by somebody else, the AI tool for the diagnosis or the AI tool to help the doctor is being provided, is being created by somebody else. The doctor is one stakeholder and the patient is another stakeholder, and maybe there is a caregiver, the relative or the attendant of the patient as another stakeholder. So in all the stakeholders, this is how the normal system works. I mean, there is very rarely a system in which actually controls end to end. So in this situation, if a AI device, IoT device or a AI platform actually is the cause of the breach or the source of the breach, then who is liable on this? Like the patient will only identify two things: the providing platform and the doctor. They don't really see what is behind the scenes.
So that's exactly what I mentioned. So when from a patient's perspective, he's going to file a case against the platform and the doctor. Now here, doctor does not have a liability. So if you see the Indian data protection bill, which is there, so it was actually supposed to be passed in the winter session, but because of the CAA issues, it absolutely went on the back burner. Now in the monsoon session, it is still predicted that it may be passed. And in that, we clearly discuss about the concept of data controllers, data processors, who are the third parties processing data, privacy by design by manufacturers. So people who are making these IoT devices, they have a very huge onus in order to ensure that they are building privacy by design into the device. So it's like they will have to get it approved from the data protection authority. So the moment they design an IoT device, which is meant for sensitive personal data, so your banking data, health data is all sensitive personal data, biometric data, they will have to get their design approved from the data protection authority. And there's a process for that. And they will have to take the guidance of them. And thereafter, they will be proceeding with respect to whatever recommendations are given by the data protection authority. Based on that, they will be conducting data protection impact assessments, speaking with stakeholders. All the stakeholders need to be consulted in this report. This report has to be submitted to the data protection authority. And then finally, you're going to go about with a device which is dealing with sensitive personal data and information. So it's going to be a very regulated method in which it is going to be operated. So right now, I would say that these laws are not applicable. But as soon as it comes about, so once you have a proper method of privacy by design built in, you have data protection impact assessments, the data protection authority regulating everything, there won't be a question of who is liable. So here, then the question of a doctor's liability will not come. A device manufacturer's liability, where things went wrong, everybody will know everything very well, and a lot of things will be regulated. Yes, a case definitely will be filed against the doctor, because for a patient, the front face is I spoke to this doctor using this platform. So that issue is something which is always going to be there. So for a doctor, he always needs to be safe. He needs to think that, okay, if I'm using this IoT device, I need to vet, is it good enough or not? If I'm using an instant messaging app, is it good enough or not?
I'm going to butt in for 2 minutes. Lawyers spend all their time in courts. When one doctor gets sued, the way he treats all his future patients And the way he discusses that with his colleagues and friends changes the entire way they look at all patients in the future. So that, it might not seem like a big deal. Okay, let's go ahead and sue and see what happens. But all these things have consequences. And then people are more interested in making sure that they protect themselves, which is really, in a way, very tragic, I feel. That everyone's doing this with good intentions. You're trying to do this.
Doctors, because the front face over here, even for the IoT device, is not going to be the company which has manufactured it.
No, I'm not disputing it. I'm
It's
agreeing.
always going to be the
Because
doctors.
what happens is the doctors don't usually have deep pockets, which is why, especially in the US, they will sue everyone because ek paisa nahi dega to dusra to dega. I get that. I'm just trying to say that this is sometimes what happens. That's all.
So
I'm not too worried though. I'm not too worried. Like I keep on saying before, people have been using telephones. People have been keeping paper medical records for many years. And actually your security requirements for some of your online consultations are far more stringent than they are for the paper medical records. Paper medical records in hospitals are treated fairly casually. I'm sure you'd agree with me. They seem to be lying around. Anyone could, look at them and stuff like that. So I think in one sense, there's a little bit more awareness. That's all for the best.
See, there are two things that will change the moment you have an Indian data protection law coming in. For doctors, what will happen is when we are looking at currently you're seeing applications like WhatsApp, etc. being used. Now, if you will ask me personally, I would use something like Signal. Signal is way more secure. The European Commission has also prescribed that it doesn't even store metadata of anything that you're sharing. So I would say that, doctors, the moment the Data Protection Act is enacted in India, they should upgrade themselves with respect to technology, understand that, why should I use an app? Both are free apps. So when it's all free, why should I use an app which is comparatively unsecure, and why not go for a way more secure app, which is prescribed by international standards? The second thing would be about prescription. So even right now, the right method for prescriptions, for doctors' communications, the ideal method, as what we say in the digital world, is using digital signatures or the PKI infrastructure. But that is not absolutely possible, let's say over WhatsApp, where I'm signing and I'm just WhatsApping a message of a prescription. So in such scenarios, the right ideal methods would still be over email, would still be over platforms like Signal, which give you this option of proper verification, signatures, things that you are absolutely in control of, as compared to comparatively nascent technologies like instant messaging technologies. So where you can integrate your emails, where you can go about doing a lot of things over a consultation, is the kind of platforms ideally that should be used. So you would be able to sign a prescription properly. You would, nobody can copy a prescription, nobody can do anything. You will have better technology at hand. So I would suggest the moment the Data Protection Act is enacted, yes, doctors need to immediately get up, upgrade your technology skills, get the right applications in place, and then there is no issue that you would really end up facing once you have the right technology at place.
Allow me to play devil's advocate. There are no rules about controlling how you mail patient records by physical mail or by snail mail. So if tomorrow I did a consultation and I wanted to mail the record to the patient, I could send it by post. So it could get lost. It could go to the wrong address, 50 different things. My limited point is our control for wet signatures is so much worse than our ability to control digital signatures. So that in a way it's actually healthy, because it's easy for someone to forge your wet signature. It's easy for someone to do all kinds of things with it. With digital technology, our ability to be able to provide protection is actually far better. Just FYI.
That's already in the way in India, actually. So hopefully by the monsoon session, a lot of things will change wherever there is sensitive personal data and information. So medical information is actually considered highly sensitive personal data. So you will see a plethora of concepts wherein you will not have physical signatures on prescriptions which are being sent over WhatsApp or messaging. Concept of digital signatures will start. That ensures entity authentication. A patient can also verify from the registry, is this genuinely the doctor? Is he really a doctor? Is he the person who has signed the prescription? Is the person I'm communicating with? A lot of things will become very easy in that scenario also. So people will also start upgrading their technological skills at that space.
Good.
Okay, and
I would like to, I would just like to come in here. As far as prescription is concerned, the guidelines also mention how a prescription is to be issued in several cases in case a doctor prescribes a medicine to a patient. And that has been given under 3.6.4. It says a photo scan and a digital and a signed copy has to be scanned and sent to the patient only if the doctor prescribes certain medicines. In case the doctor does not prescribe any medicine, he normally does not give a prescription, but he needs to give a signed and a scanned copy of a signed prescription. And also it says e-prescription could be given. Now what the rules lack is it does not define what an e-prescription would be. But going by my common understanding, it would be a digitally signed prescription majorly. So what
Yes.
would be the modes of that? That has to be actually seen. Yeah.
That the
Okay,
Indian
here,
Data Protection Bill is already encompassing for sensitive personal data. So it's going to be digitally signed prescriptions over
okay.
secure mail. So those guidelines will come in the moment our monsoon session kicks in. I guess.
Okay, I just want to barge in here and ask one to Puneet and Aditya, both of you. Like you mentioned digital signatures like n number of times. So what I want to know is which kind of digital signature are we talking about here? Because what my experience says is doctors consider even a scan or a photo of the signature as a digital signature. Like that is the common understanding. So is it a photo of the signature that is inserted into a PDF? Is it a DSC, like the digital signature certificate that is given by the government for certain purposes, like for incorporation or for filing taxes? I mean, you get a DSC on a USB. So is it that level of thing, or is it just a digital signature that is created using a platform like HelloSign, which is actually valid for legal documentation? So which kind of a digital signature are we talking of here?
Right now, a scanned sign is okay because as per the current guidelines, the moment you have the Indian Data Protection Act coming in, we are talking of proper digital signature certificate. Then we are looking at
Okay.
proper DSC being attached to an email of a prescription being sent out. We are looking at a very different format of e-prescriptions. So where even a patient can verify that I have received, see, in an email also there are man-in-the-middle attacks, hacks that occur. So how will a patient verify that this doctor has only sent me this prescription and nobody has tampered it in the middle? So that tampering in the middle can be verified by a patient by going to the registry, re-verifying using the public key of the doctor, that the private key, which is the digital signature with which he has signed, is the same person who has made this particular document. So before consuming a medicine, a patient can actually verify that genuinely this doctor has only sent me the prescription. Nobody has tampered with anything in the middle of the communication.
I think yes, what Puneet is saying is right, because as of now, the guidelines only say a signed prescription needs to be photo and scanned and sent to the patient, and the rules does not describe e-prescription. Now, if the guidelines, when the Data Protection Act comes into force, and I think there should be strict guidelines which should be made. Even the certifying authority rules and the digital signature rules, DSCN should be properly attached so as to make sure that there is sanctity attached to that prescription. So
Yeah.
that is very important in case the prescription is not signed by the doctor physically.
Okay, so I think we have covered most topics and questions. So I think we have a lot of questions coming in. Okay, this is something interesting from Rahul. So he's asking, is there any criteria which can be used to evaluate telemedicine platforms or providers? Like, as far as my knowledge or like opinion goes in this situation, it is something that a patient has to choose from reviews and stuff.
Yes.
But what I feel is that along with this regulatory guidelines for telemedicine, which specify rules applying on doctors and prescriptions, we should be coming up with a legal guideline to like have some basic criteria which a platform has to fulfill.
Must fulfill.
Can I say something?
Yes, please come in, sir.
I think we need to understand that we're also working within an ecosystem. There are lots of other players. There are insurance companies which will want to offer some of these platforms. The government will want to offer some of these platforms. Private hospitals will want to offer these platforms, medical associations. And I think typically the good thing about any system, a democracy or a market-driven system like ours is there'll be lots of competition because it's early days. We still don't know what will work well, not work well. But finally, something will rise to the top, which has a lot of this technology and the safety built in, so that effectively it becomes as friction-free as using your mobile phone. So just another tool. You know, quite frankly, doctors use mobile phones far more frequently than they use stethoscopes. And I think that's just going to become much more mainstream.
Okay, and we have another question. I think this is for the legal experts that says that in for Ayush practitioners, specifically, it's a very specific question. Ayush practitioners are allowed to prescribe a limited set of allopathic medicines in some states like Maharashtra. Okay, Now,
I think
telemedicine guidelines allow you to practice without a border of the state. Like if you're registered in one state, you can practice all over the country. What happens when such regulations don't match? Like if the patient is in a state which does not allow Ayush practitioners for allopathic medicine, and the practitioner is in a state which allows it.
This is simply the practitioner needs to, first of all, that's where we come about the concept of understanding the patient, consent. So consent and giving the prescription, giving the treatment is going to be based on the concept of even jurisdiction. So, like for example, even other issues in cyber laws today, like when a platform is like the same issue is online gambling. In some states it's allowed, some states it's not allowed. So the moment you get a person who wishes to play on your platform, you first take a verification from them. Do you really belong to this state? So your liability with respect to that, you have already clarified you don't belong. Now, if the person lies, that is something that is a different scenario, but you have on record the person has stated something like this. So the same
Actually,
analogy would follow even for a patient, where you would have to verify the credentials of the patient. So is he from the same state? Is it okay then for you? And you have it on record. So tomorrow you will not face any problems, where on record you are taking a clarification from him and then providing a service.
I would just add on to this that before any registered medical practitioner can prescribe any medicine, Ayush or any sort of medicine, he has to do some basic exactly the checks. For example, he has to first of all see any appropriateness of the telemedicine, whether it is possible or not. Then he has to see the identification. Both the doctor and the patient both has to identify each other. Identification in person as well as the conditions. Then there is appropriateness of technology, whether this technological platform which we are using would be through this would be able to give you the best telemedicine consultation or not. Patient consent, patient evaluation, and the patient management. So after these five concepts, after these five essential guidelines, which are the which are basically the which are specific to the telemedicine, only then a doctor can give teleconsultation to the patient. So it is very necessary that the person, both of them have to identify each other, which state you are from, which state, whether we can prescribe you such medicines or not, which kind of pharmacy will deliver you these medicines. All these would be guided through these guidelines itself. Hello, am I audible?
Yeah, you
Okay,
audible, I
I
think.
think Neha's voice is breaking up a bit. Pardon?
Yeah, was I audible?
Stop my video maybe. I think I missed the last part, but what Puneet was saying is you were audible to everybody
Okay.
except me, so it's fine. So we can just proceed. I think we'll have to start wrapping up because I am getting reminders about that 1:30 we have to finish. So, okay, one thing I would like to add from my personal point of view, like I have been in clinical practice and I'm trained in public health. So what I feel is telemedicine per se in terms of Indian context, it has a huge potential of playing a great, like a great kind of a change can come in, which will actually help us deliver quality healthcare or at least quality advice to a lot of remote, not reachable or inaccessible places as of now. We can actually increase the reach of quality or specialist care far and wide. But along with the same, what happened, what Dr. Malpani was saying in the previous question and what Aditya said in detail before about the Mumbai High Court judgment in 2018 October, I guess it was September, October, sometime like that.
October, yeah.
So, yeah. So what happened is after that, for almost 6 to 8 months, all doctors, irrespective of their location, their place, or whatever, everybody was like scared of taking any kind of teleconsults. They were literally scared of touching a patient or prescribing or even telling a medicine on the phone because everybody was afraid it was like viral on a lot of internal societies like doctors associations and stuff, and everybody got scared. So what we need is a really enabling environment that goes and that adapts quickly with the situations that come up. instead of having to wait this 20 years and a pandemic for basic guidelines to come up, we have to be very agile on it. The guidelines have to change like maybe multiple times before we can get a very clear idea of how we are working on it. So I think we can start wrapping up. What I personally feel is that from a legal point of view, these guidelines are very fresh. They have already put in two addendums and changes after that. Like after the March 25th guideline, there was an addendum on the April 8th. There was another on the 18th of April. And I think there has been another update in the medicine list after that. So there have been already three like addendums and changes to it. So what we are probably looking at is a very flexible, like very changing environment that we'll see for some time, maybe a couple of years. The training courses have to come in, people have to get adopted. I mean, yes, but one thing I am like absolutely sure and everybody agrees and we have all seen is that telehealth consultations, people adopting it or doctors adopting it, the numbers have gone up really fast with the lockdown and with the current COVID pandemic. But as to use it for a regular situation and to bring it really, to really unleash the potential, we have a long way to go. Doctors have to be comfortable, patients have to be comfortable, everybody has to understand the law and the limitations, because patients might expect the doctor to deliver all the care. And what clause we have of adequacy of treatment or adequacy of making a diagnosis, the doctor says no, this is, I cannot make it, it's not possible, but I have already charged a fee for it. And the patient says, anyway, I have to go to someone, you didn't do anything, you just saw me on video and said go to a hospital. So that expectation setting has to be correctly done from both sides, what can be done, what cannot be done. And maybe over a longer term, we are actually looking at a lot of change and a possible great improvement in healthcare facilities or healthcare reach at least. Like now we can have, as we are discussing, we can have IoT devices in the house which the patient uses to monitor. It can give alerts, it can send the data to the doctor can consult back if required. So a lot of things can happen, but there has to be a very clear framework, because otherwise what will happen is every once in a while we'll face a fear, we'll face a threat, and then everybody and things will go back to maybe 1-2 years backwards. Like what happened with the Mumbai High Court judgment, that everybody for 6 months or a year, everybody was like absolutely scared. So that kind of situation should not be happening. We should be preempting those situations as much as possible. So maybe some closing comments from all of you, Neha, Aditya, Puneet. I think Dr. Malpani has dropped off.
Yes, he's not there.
Okay.
Yes, I would agree. I actually agree that with respect to these guidelines, these are very legal and very technical. But let's understand from a point of view of the public that and the government that access to healthcare is a right. It is a right. It's a constitutional right for everyone. And see the situation of the places who are in the remotest regions who cannot have any access to healthcare. So this telemedicine, e-health is very essential for those people who are actually it will bridge the gap, the geographical gap, which is from where from for those people who cannot reach to us, who cannot reach these hospitals, who cannot reach even basic diagnostic services. They cannot get their ECG or they cannot get their ultrasound done. Secondly, various kind of medicines, various kind of things, various kind of applications this telemedicine pose. And one of the good achievement and good actually application is with respect to pediatrics, dermatology, and the telemetry, as well as the mental health, which can be easily done through telemedicine. See,
I'll
some
just
burden.
let me interrupt here right now, because
Yes.
otherwise what happens is by the time we finish, I'll have lost its train of thought.
Yes, yes.
We all of us accept, like I personally accept, you accept, most people in lay public and doctors accept that telehealth has a big role to play in mental health, especially in India, where
Mental
it
health.
is considered a bit of a taboo still. Like most people don't want to talk about their mental health issues. At the same time, the guidelines say that you cannot prescribe a Schedule X drug in any condition on a telemedicine. So how is a psychiatrist going to prescribe anything if it's not allowed, if it's not allowed to be prescribed?
No, there are kind of drugs which are prohibited and some drugs which can be allowed. Over the counter medications are allowed. See, telemedicine doesn't say, it is not just about prescribing of medicines. It is about even teleconsultation, tele-advice. So that advice is not prohibited to be given. any kind of medicines which are prohibited under the NDPS and Drugs and Cosmetics Act, which are also prohibited in the list the list X, which are the scheduled drugs. These are also prohibited here also.
No,
So,
no, no. But this thing is with Schedule X drugs, most psychiatric medication comes under this category. Most of it,
yes,
except for
Yes,
maybe
yeah,
three
you're
or
right.
four, most of it comes in
Hmm.
here. And what happens is if a patient is taking a mental health consultation, a psychiatric consultation, I can understand a clinical psychologist or a counselor talking with the patient. That is one aspect that can be done safely, that can
Yes.
be done perfectly. What happens if there is a need of prescribing a medicine? The patient is maybe 200 kilometers away. There is a need of prescribing a medicine. The doctor cannot legally do that. He is bound, he or she is bound by a certain sense of uh, like a duty to prescribe, but he or she cannot prescribe because of
I
the
would
law.
I would like to come in here. I would like to come in here because these are just guidelines. These have not been developed into a codified law. So a mechanism could be adopted wherein in urgent and extreme circumstances, a particular authority could be formed or a particular council could be given the powers wherein in extreme emergent situations, a psychiatrist or a RMP is allowed to prescribe Schedule X drugs. So a mechanism could be adopted for that. Now, I'll tell you what happens only when cases come up and only when certain kinds of suggestions are given to the ministries, that's when they develop the law. So I would urge all of you, all the doctors, medical councils, and all the registered medical practitioners to submit your submissions to the Medical Council of India and to the Niti Aayog, because these guidelines are not a codified law yet. These have yet to be passed in the parliament, and then only then they will become a codified law. So I would request you to do that. Secondly, one more aspect I would like to, as a closing comment, I would like to say is the issue of jurisdiction. Like if, like you just said, your last question, basically a doctor based in Delhi is advising a patient based in say Chennai. So how will we see what will be the jurisdiction and how will we fix the accountability? For that, I think we can take cue from the law in the US. Now, the law in US says a physician delivering medical services via telemedicine must be licensed in the state where the patient is located. So we can take a cue from that, and we can make sure only if a patient is in Rajasthan, so only a doctor in Rajasthan can give him the telemedicine advice, so as to fix his accountability and so as to make sure that all the guidelines are fulfilled. So I think we can take a cue from the US law
No,
for that.
but in this situation, I think the way the law treats the medical licensing is different in the US and India. In
yes,
US, they give a license based on the state,
state.
whereas in India, it is nationally valid license. So I can actually go and practice. No, I can register with a particular state's medical register, but
And you
that
can practice
automatically
somewhere
gets
else.
Practice anywhere,
updated in the
exactly.
IMR,
Yes,
and then I can practice anywhere. I can actually
yes.
Exactly.
practice anywhere as far as
Yes.
Indian laws are concerned. So the question was not about this, but it was basically about one state allowing a set of like things that I can do, and another state not allowing. And when the patient and the doctor are in different places, how this discrepancy can be managed.
So this
But
discrepancy, as of now,
I
the
think
consultations are going on, and the government says that in kind of such kind of cases, there would be a local physician also, which would be involved. Okay, so in the rural areas and in the remotest areas, some local physicians and local clinics are already always there to
but
take care of the patient physically if
no, no,
some
no, no. The
emergency
local
happens.
again now it comes the local physician, whether that person is actually a physician or not. We have a big problem there.
No, yeah, it is a physician. It is a physician, but the specialty it is not a specialty clinic, but
Then
it
it
is a
can be
physician.
then it will be RMP to RMP
Yes,
discussion between a
yes,
generalist with a
yes.
specialist. That is
These
perfectly
guidelines have to be come out to be more comprehensive with respect to the case to case and the factual basis. Now they
Yes.
have also enlisted emergency services, like you tell that someone want to consult a psychiatrist and he wants immediately a medicine which is maybe restricted and it cannot be given under these guidelines. So what will happen in then? So these will be listed in the emergency services this doctor can give, and only his professional judgment is enough to what to do or what not to do. Some
okay.
things have to be more comprehensive now, coming into the facts and
Okay,
circumstances of
and we
these
have
cases.
one more question that has come in late, like now, I guess, and that is about what does the law say about taking informed consent through website in general? What I understand is for teleconsultations, for any kind of health consultations, this general consent that we take, the end user license agreement or the general does not apply. We have to take specific consent each time we consult. For each test we do, we have to take a specific informed consent. I think I'm correct. The laws can help. Hello, am I audible?
Hello. Yeah.
There can be no pre-ticked boxes. So what the law clearly
Yeah.
mandates, even under data protection, is that you cannot have pre-ticked boxes. It has to be very clearly written without legal jargon, easy for a person to understand, like probably just in a paragraph. So it cannot be something like, I agree with a link that has 50 pages into it. So it just has to be 4 to 5 lines, very clearly mentioned. I agree should be, again, not a pre-ticked box. It has to be where I am personally consenting. And these conditions, if complied with, will make it to some extent a valid consent.
No. The question that came in was about whether this kind of consent taken generally when a person visits a website. Like at the beginning, if I'm going to consult someone on a platform, let us say whatever it is, it's 1mg or Practo or MFine or MedTel or whatever, I go on the platform, I log in. Initially, it asks me to tick 2 boxes like terms of service and consent, and I agree. Okay. So whether this is valid for taking telemedicine consultations in the future
Yes,
or what?
yes, yes.
But
it
I
is.
understand, Neha, is it is not every time, every single consultation has to have a separate.
You have to take a separate
Yes.
consent for each doctor.
Implied. Hi.
No, even for the
Right.
same doctor, it has to go in multiple. Like every
Ye-
time there is a consultation, there has to be a consent going in.
Implied consent. Exactly.
Initially, when we log into a website or any technology platform, that won't be that would be a general consent which we give generally. For example, consider the case of Arogya Setu, which the government came up. So when we downloaded it, it was a informed consent only, which they taken from us, and that's how we put all the details: our name, our credentials, date of birth, and our medical conditions, everything.
See, all these platforms that you see which are offering a connection between doctors and patients are basically, in simple terms, they're e-commerce platforms. And
Yes.
what you're seeing are the terms and conditions privacy policy of the e-commerce platform. It is not the terms and conditions of the doctor. It is not the terms and conditions of the privacy of the doctor, privacy policy of the doctor. It has got nothing to do with the doctor's consent or the patient's consent over there with respect to treatment.
Exactly.
It is the e-commerce platform's terms and conditions and privacy policy. Basically, that is what it is.
Should patients be aware of that? Like who is responsible for making
No. The
patients?
technology platforms are responsible for that
Responsible
because
for that.
guideline five
Using
of these guidelines, it
No,
imposes
no. My question, Aditya, is like who is responsible for making the patients aware that this is an e-commerce platform and not a healthcare platform?
there has to be a disclaimer over there.
Yeah,
So
yes.
ideally, when we see disclaimers, when we are drafting
No,
that for any platform,
there is a disclaimer. There is a disclaimer, but as you said, it is at page 50.
that's the problem. So a valid consent cannot have 50 pages. The EU GDPR and even the Indian Data Protection Bill mandates
Yes.
it in simple words. That's why I started off with the first point.
Yeah.
One paragraph, simple words, no legal jargon, no 50 pages. That's how exactly it has to be.
Clear and unambiguous. Yeah.
Yes, clear, unambiguous, unbundled, granular. These are the descriptions of how your consent has to be.
That is true, because even when we take a consent, we have like multiple sections to it. Like this kind of data will be used for this kind of
Yes.
data cannot be used for this. This is what you are actually consenting to. Yeah, maybe it needs to be simplified. As you said,
Actually,
one
actually,
paragraph
there
clear.
would be a technology contract between the doctors and these technology platforms, the RMPs, and this also would be. So the hospitals and these websites would be doing a technology contract where they would be enclosing all these terms ki what kind of data which you are, जो patient का data है जो हमें मिल रहा है, for which we are getting paid, how much you can disclose it, and if that loses, if there's some data theft, and there's a privacy issue, so who would be responsible? So that would be between those two people, the hospitals and the technology providers.
But shouldn't the patient be a part of it? It's ultimately the patient's
Patient is
data
a
that
part of it. No, patient is definitely a part of it, but the clinical establishment and the person who is giving and the people who are giving these technology, they have the consent would be between them two. The contract would be them between them two.
Okay, I have one personal question that has been like a kind of like thought-provoking question that I read about sometime like 1 or 2 months back.
Which
Actually, I discussed it with Ramanuj once also. So
Yeah.
this is for the lawyers. Like, let us see the system. There is a platform or a device or something that takes the data of the health data of the patient. Then there is an algorithm that learns from it, the machine learning or AI algorithm that learns from it. And then the AI algorithm can be put to use in a new scenario. Let us say there is a training data set, and then there is the actual algorithm that learns, and then there is a implementation set that when the algorithm actually goes into deployment, it starts giving some results, right? Let us say I train a particular algorithm to identify X-ray pictures for coronavirus. Like there are like 10 AIs doing CT analysis of for coronavirus lung CT. So fine. So now this question is, who actually owns the rights on that AI? The developer, the patient whose data was fed into it, the hospital or the doctor whose diagnosis or judgment was fed into it, everybody, or it is something like everything goes to the technology developer and they have the rights on it. Like this is off the record, but it is related in a way. This is something that might come up in a bigger challenge in a few years, not now. Once actually the AI tools are monetized, till now nothing is monetized, so nobody is asking anything.
See, as of because as soon as you have the data protection bill passed, it belongs to purely to the data subject. He has to consent to give you anything. So the pure ownership of everything related to a data subject lies with the data subject, that is the patient. The patient is the data subject whose data you're talking about. So as soon as we have the Data Protection Act and even under the EU GDPR, the same concept is enunciated. So even in India, our data protection bill talks of the same thing. Now, right now, if you're looking at the period, there is no guideline. So what is tending to happen is that a platform which is providing you a service is taking all the rights from the data subject, that now this rights belongs to me, your data belongs to me. Now,
No, Puneet, that is not the question. That part is very clear. The data belongs to the patient. GDPR guidelines are probably the most stringent in the world right now, and they're very clear about it. They're like very specific and very clear. This can be done. This cannot be done. No, I'm saying if the data, anonymized data of the patient or the anonymized data taken bulk from a patient from a hospital is used to develop something in technology that at a future point of time is monetized. Okay, and then the same thing is being sold back to the patient, which was developed from his or her data. So can it be done? Is it ethical? Is it legal? That is my
ownership of the data.
Not ownership of the data itself, but ownership of what comes out of the data.
If that is used and that is monetized in the future,
yes.
Who would be held responsible for that? As Puneet rightly said, the Data Protection Act is coming for that, because as of now there is no particular framework for that. And when the Data Protection Framework Act, that will introduce the principles of data principal, data fiduciary, and data intermediary, and that would fix liabilities on each of them. So only then there will be some clarity on this topic.
Okay, I think we have to close in now.
Yes.
So it's a research, who owns the data, the platform, the hospital. I think we have a question coming in about who owns the data. We have a pretty clarity on this, like as per the coming guidelines that are going to come up, which are to a great extent model on the GDPR guidelines. So I think the ultimate ownership remains with the patient. The patient can choose and pick what to allow the data for. The patient can even refuse research uses. The patient can refuse anonymized data analytics.
Right to be forgotten, yeah.
Right to be forgotten has to be there. And the duration of forgotten has to be there. Then the duration of storing the data has to be there. And the conditions on which that stored data can be reshared with people has to be there. Like, okay, we have a situation of an epidemic or some public health issues in which it has to be mandatorily shared with the government. There are some legal issues in which it has to be shared with the court, or it can be shared with the court under certain conditions. But apart from that, the ownership lies with the patient for all practical purposes. Right. So I guess thank you everyone for joining in. Any ending comment from Puneet? I'm sorry, you didn't get a chance the previous round. And I actually extended the discussion.
With respect to using telemedication, having the right applications and the right knowledge from a patient and a doctor's perspective is very important. So here it's not just doctors, so even patients can insist that they want secure application usage. So as I mentioned earlier, using secure devices is important, using secure applications like Signal is important. So where you're basically reducing every form of risk and taking absolute informed consent with full compliance of the guidelines. And as soon as, I would say, within the next 1 or 2 months, once the Data Protection Act comes in, that's when we are looking at way more stringent compliances coming into place. Until then, yes, using secure devices, downloading adequate malware protection, spyware protection for a doctor, all of these in your devices is of key importance. So tomorrow, even if anything goes wrong, you have all proofs to prove your innocence. See, end of the day, you cannot control what the other person is doing. You're going to teleconsult 100 patients. Out of that, one patient will just have something in their mind where they feel, oh, this was not done right. Because end of the day, see, let's take an example of a skin condition. So you do a video call of a skin condition, or you send a photograph of a skin condition. Now, just a video call or a photograph, a doctor may not be able to ensure it's a rash or it's a chickenpox starting, or is it that you have developed some form of extreme eczema. So, or it could even be herpes for all. So to some extent, a doctor can decipher, but without touch and feel, without actually, even in cases of leprosy, doctors, actually dermatologists touch the patient, they press those spots to understand, is there some disease there? So here, without doing anything of that sort, you are purely basing yourself on an image or a video. So there is going to be certain differences, which again, some patients will understand and some patients will simply not adhere. They will simply be like, oh, why was I given this medication? Why wasn't the diagnosis perfect? So there is always going to be a scope for error. So in my opinion, it's always better if the doctors have everything well recorded. As I had earlier on mentioned throughout the session that, recording of the entire documentation, recording of past history, proper signed prescriptions, using secure applications like Signal for communication, which can be recorded. So having all your records placed properly, including record of consent. So this is going to ensure that even if you're dealing with a patient who has not fully understand the implication of telemedicine. See, yes, a normal patient like today, if I'm consulting with somebody in telemedicine, I know the scope for error. But every patient may not understand that scope for error. So you need to understand, even if you deal with one such patient, your life can be held. So you need to ensure that you have a proper process set in place for your practice. And especially Corona is probably going to continue for a longer time and things would continue in such a fashion. So it's better to have a process in place which applies to everyone so that, even that one patient can be covered in the entire scenario.
Okay, so what I gather from today is like we discuss a lot of things. A lot of it focused on legal aspect, the data privacy. And Dr. Malpani talked about information therapy and how it is actually going to help healthcare in general, how it is going to help improve outcomes in patients. I personally feel it has a lot of potential for population health levels, like public health outcomes can be improved a lot, because once we empower our frontline health workers like Ashas, Anganwadi workers, ANMs with proper digital tools, they can actually spread healthcare to a much larger extent. But that is thing for government and policymakers to do. As a doctor, as a telehealth practitioner, as a running a telehealth startup, coming to, like, I'm specifically saying what Puneet said, that actually makes me feel like it's going to create a lot of scare, but it is also going to create a lot of opportunity and a chance to overhaul the system for the better. Because once the data protection rules come into play, the law comes into play, a lot of doctors, a lot of patients, a lot of platforms have to upgrade themselves mandatorily. Things will become more transparent, more clear, and easy to understand. And I hope that gives both sides, the doctors, the patients, and the platforms, all the three stakeholders, or even more. Like we have pharmacists, we have nurses, we have other paramedical staff, the support staff around it. All of them will probably coordinate better and in a more transparent fashion, which will actually lead to better outcomes for the patient. So I think, yeah, another, like, not a question, I think we are running out of time. So one thing is, what do you see in terms of this being a new field of law? Because this was where this entire webinar idea started. I mean,
Yes.
when we are trying to get ideas, and Ramanuj is trying to get ideas, I said this might become a new field for law even. And just like it has opened a new field for medicine, it will probably open up a new field for law in dealing with telemedicine, its compliances, its data compliances, its litigation, all that. So what do you see of it? Like, is it another opportunity opening up for lawyers?
Yes, definitely. I would say it is opening up a lot of opportunities for lawyers, because the doctors and the physicians and the smaller hospitals, majorly the single specialty hospitals, as you say, they need to be aware. If you make them aware of these guidelines, if you make them aware of all the regulations are, and what are the practices that they need to adopt, what are the systems they need to inculcate. So I think it can become a good area of practice in terms of a lot of advisory, contractual work for lawyers can flow in through telemedicine. Also regulatory work. Regulatory work in the sense who to get registered with, where to get registered with, how to get registered with, who, where, and how. Litigation, I think litigation would be majorly medico legal, because that would be basically post treatment. But pre treatment and how to start your telemedicine practice, that could become one good area for lawyers, which they can speak about to, I think, doctors and hospitals.
Also, with respect to the business propositions, these websites will open, technology platforms will keep on developing. So there also a legal team would be developed. There would also a legal team would be prescribed for particularly dealing out of the telemedicine guidelines. They have to follow each and everything which has been raised in the telemedicine guidelines for the web portals also.
Okay, so we have an opportunity coming in for lawyers here. We have an
Yes.
opportunity for doctors to
Yes.
upskill and train themselves or retrain themselves to cater to this. And we probably would have a explosion of outreach, I mean, the reach of healthcare in general. So I'll thank everybody. And Ramanuj is there, but he is not able to speak and be seen. So otherwise, he would have taken the session. Anyway, thank you everyone for joining in. I think we can end the session now. And Bhavna or who is actually?
Yes, sir.
Yeah, Bhavna.
Thank you so
you-
much, Mr. Timiresh and Puneet and Neha, for the lively
Thank
discussion
you
we had.
all. Thank you all.
Yeah,
It was nice.
thank you, Neha. Thank you, Aditya. Thank you, Puneet. Thank you, Bhavna. And I think
Thank
we
you,
can
sir.
end it now. So I don't have the control to end it. I can
So
leave.
I'll, yeah,
Yeah.
you can see, I'll end
So
it.
I say thank you, everybody, all the participants who have been here asking questions and who have been joining us. And thank you, everyone.
Thank you,
Thank you,
everyone.
Timiresh.
Thank
Yeah.
you. Thank you.
Bye.
Bye.